Hi everyone, you are welcome to this edition of our program on United Nations and international border demarcations. This program is relevant based on the recent redeclaration of Republic of Biafra independence on 29th November 2024. The need to approach border demarcation in accordance with UN International Standard Method of border demarcation is therefore necessary. However, before we go on, Macmedia wishes to use this opportunity to thank all our subscribers, viewers, and admirers, and say to you all, Happy New Year. It is hoped this new year will bring you much required blessings from your desires, give you more understanding, wisdom, and knowledge. Yes, let us go back to our topic for today. Recently, Biafra was redeclared like many other independent nations. Although one would not be surprised, the parent country, Nigeria, and some of its citizens may reject the declaration and say it does not mean anything. But let me give another assurance. This declaration stands in accordance with international law. For historical fact, the present-day Biafra was part and encirclement of Niger Coast Protectorate. This was the only protectorate presented before the Berlin Conference of 1884. Every other protectorate created by British colonial adventurers were not presented before the Berlin Conference of 1884. At Berlin Conference, they called this protectorate Oil Rivers Protectorate. It has its own international boundaries and demarcations from other protectorates later created by the British Royal Niger Company. This is presented in this very map called Niger Coast Map, which had greenish colors within the encirclement of the boundaries. This protectorate, with its boundaries and administrative headquarters and activities, existed until 1906, when Egerton Water, the British colonial administrator, joined the Lagos colony or integrated the Lagos colony into Southern Protectorate, otherwise called Niger Coast Protectorate. Despite this, the boundaries of the Niger Coast Protectorate was maintained. Therefore, there is no cause for alarm in terms of international boundaries and demarcation. The historical fact is clear. These borders also did not alter, even when British Lord Lugard amalgamated both North and South. In 1914, these were transformed regions: the Northern region, the Western region, and the Eastern region. It was later that Nigerian politicians decided to alter the boundaries, but that alteration has nothing to do with the international boundaries, because the international boundaries were created by the British administrators, and that is why we have to listen to the international lawyer on border demarcations or international boundaries of the new states. Nevertheless, one will not fail to point out some certain issues that may affect the new boundaries or the persistent refusal by the Nigerian government to acknowledge and recognize the fact that Biafra has left the Union. Any refusal to acknowledge this is caused by fear of losing the resources they use to maintain other regions like the Lagos colony and Northern Protectorate, of which they are not even using to maintain the services, but for individual acquisitions. To many Nigerian politicians, the declaration of Biafran nation is like a biblical Sahindrin. Despite the angelic guided birth of Jesus Christ, the Jerusalem Sahindrin escalated opposition to Jesus, from the synagogue closures to a court process before Pilate. And this is exactly what is happening within the Biafran context in the Nigerian setup. What motivated the Sahindrin included fear of losing power, blasphemy charges, perceived threat to their authorities. Therefore, border issue with Nigeria is that which calls for a memorandum of understanding between the two parties. From the map presented so far, you find out that the 40 states of Biafra still remain within the context of the Niger Coast Protectorate boundaries, international border demarcation between Biafran nation and Nigeria state. Based on Nigerian activities, even before the war and after the war, we will look at what the United Nations says regarding international border demarcations. Quote, the United Nations regards the adequate delimitation and demarcation of international boundaries as a very important element for the maintenance of peace and security in fragile post-conflict situations, establishment of friendly relationships, and cross-border cooperation between states. It continued, since international boundary issues are multifaceted, indeed, a range of expertise is required, and the United Nations Secretariat is in a good position to provide diverse expertise within the multiple departments. It continued, expertise in different departments, ranging from legal, political, technical, administrative, and logistical, are mobilized in different ways to provide support to member states depending on their specific needs, unquote. With today's Mark Media brings in a national lawyer to explain more, and therefore everyone, especially Biafran government, legal teams, and Nigerian counterparts, should listen and listen attentively to the advice and the explanation of the international law. As stated earlier, the motive for bringing this program is to alert the people, Biafrans, Nigerians, and the international community about the existing boundaries created by the British colonial authorities, which was regarded as international border in contest.
Disputes about territorial delimitation and borders have been recurrent in interstate relations throughout history. Wars have been fought over territories, but hopefully peaceful means of dispute settlement have also been developed and often used in matters of border disputes. To mention some of them in relation to the emergence of new states. The first rule to be mentioned is the automatic succession of states to treaties establishing international borders. Borders are usually established by common agreement between the states concerned, and those treaties are, as we shall see later when addressing the law of treaties, those treaties are binding on the contracting parties, and on the contracting parties only. As a matter of principle, treaties are not binding on third states, that is, on states that are not parties to them. And when a new state emerges as a result of a secession, that new state is by definition a new subject of international law, and it is not party to the border treaties that were concluded prior to its emergence. For instance, when Czechoslovakia disappeared as a state and was succeeded by the Czech Republic and the Slovak Republic, none of those new states were formally party to the borders treaties that Czechoslovakia had contracted with its neighbors, with Germany, with Austria, Hungary, Ukraine and Poland. Would the new states be entitled to claim that their borders do not exist with their respective neighbors because they are not party to the border treaties concluded by the former state, now a deceased subject of international law? Well, the answer to that question is no. There is a rule of state succession. Despite not being formally party to the border treaties, the new state automatically succeed to the rights and the obligations of the mother state under the border treaty. And this is a long-established rule of international law. It serves the purpose of stability in international relations. And it is an exception to the principle according to which treaties are only binding on the states that have formally consented to it. A principle which is a cornerstone principle of the law of treaties that we should address. Another principle applicable when new states come to exist needs to be presented. It also relates to borders, but it relates to the establishment of new international borders rather than to the stability of existing ones. The principle is expressed by the Latin maxim Uti Possidetis juris. Historically, Uti Possidetis juris was first used in the context of the Latin American decolonization in the early 19th century, while the borders between the Portuguese possessions and the Spanish provinces were automatically stabilized as a result of the rule on state succession to border treaties. It was agreed that the new international borders between the former Spanish provinces that had become new independent states, those borders would be the administrative lines that had been established by the Spanish crowns. Later on, when the European colonial empires in Africa were dismantled in the 1960s and the new African states were established as a result of the right of peoples to external self-determination, many African leaders confirmed the territorial status quo at the time of independence and pledged to consider the former internal colonial division lines as new international borders. The first summit of African heads of states meeting within the newly established Organization of African Unity proclaimed in July 1964 the intangibility of frontiers inherited from colonization, and it referred also to Uti Possidetis juris. In other words, not only the international colonial borders that existed between, for instance, the French and the British possessions in Africa would be kept, but the internal lines between the former French territories existing under French colonial administrative law, or the internal lines between the former British territories existing under British colonial law, those internal lines were transformed into international borders. So, for instance, when Burkina Faso, which was formerly called Haute-Volta at the time of the French colonial empire, when Burkina Faso and Mali became independent after having been French colonies, the internal administrative line that had been established by the French colonial administration was transformed into an international border between those two new states. Of course, when the application of Uti Possidetis juris results from the agreement of the parties concerned, there is no much legal problem. That agreement provides for the legal basis for such application. But what happens if there is no such agreement? Does Uti Possidetis juris apply as a rule? That is, are internal administrative boundaries automatically transformed into international borders, even in the absence of any agreement between the parties. In a territorial dispute between precisely Burkina Faso and Mali, where the two states referred to Uti Possidetis and to the intangibility of frontiers inherited from colonization, the International Court of Justice generalized the application of the principle of Uti Possidetis and considered it as a rule. And the court said this, I quote, Uti Possidetis juris is a general principle which is logically connected with the phenomenon of obtaining independence wherever it occurs. Its obvious purpose is to prevent the independence and stability of new states being endangered by fratricial struggles provoked by the challenging of frontiers following the withdrawal of the administrating power. So the court considered Uti Possidetis as a general principle and said it applied even outside the colonial context. The court stressed that the use of Uti Possidetis in Africa was not to be seen as giving rise to the emergence of a new rule of international law, but I quote, as the application in Africa of a rule of general scope. In 1986, when the court delivered its judgment, this was probably a bit far-fetched because Uti Possidetis had only been used in two specific colonial contexts, in Latin America and in Africa, and that each time the application of Uti Possidetis resulted from the agreement of the states concerned. A few years later, however, outside any colonial context, but in the context of the dismantlement of the former Yugoslavia and the wars resulting from it, the question of the territorial delimitation between the new states that had declared independence became extremely controversial. And in a legal opinion delivered to the Peace Conference on Yugoslavia by the Arbitration Commission chaired by Robert Badinter, who was at the time the president of the French Constitutional Court and the former Justice Minister of France, the Arbitration Commission referred to the judgment of the ICJ in the Burkina Faso Mali case and concluded that Uti Possidetis applied as a rule and by default. The internal boundaries existing between the former Yugoslav republics were said to be protected under international law as international borders, and they could not be changed except by agreement. In other words, Serbia, Croatia, Bosnia-Herzegovina, and the other Yugoslav republics had no choice. The borders between them ran along the old administrative lines that separated them when they were living together as federated entities of the former Yugoslavia. Uti Possidetis juris was thus applied outside the colonial context. The big powers that played a role in former Yugoslavia wanted Uti Possidetis to apply, and the states concerned finally agreed to it. From that evolution and that practice, it is difficult to escape the conclusion that Uti Possidetis juris would most probably apply again as a rule in future cases of secession. Like state succession to border treaties, Uti Possidetis juris promotes territorial stability and therefore promotes peace. Of course, the new states remain absolutely free to agree to draw their borders differently. But the line resulting from Uti Possidetis will apply by default and will most probably serve as the starting point of any border negotiation. However, and even if Uti Possidetis is considered and applied as a rule, this does not always solve all the problems. And indeed, in some states, various internal administrative lines of provinces, of departments, of regions could potentially be transformed into international borders. And Uti Possidetis does not say which of these lines should be used and turned into an international border. Therefore, the application of Uti Possidetis will not be so automatic, and it may require some prior negotiation and agreement about the relevant administrative boundary that has to be transferred.
With today's, we come to the end of this very program. We ask you to subscribe, like, share, and leave your comment. Thank you for watching. God bless you in this new year. Do not harbor any anger against your brothers or your sisters. Resolve your issues amicably and continue your life without rancor and hatred. Thanks and God bless you all. Bye. Okay.